Thank you everyone for being here. Thank you to the center for having me, for inviting me for this occasion. As some of you may recall, in the original brochure plan program of this conference, it was another professor, the one that was going to give this part of the talk and the analysis of this law. Sadly, she couldn't make it, so someone of the team had to. And well, I decided to do it because I am from the neighborhood. I'm from Chile, so I think it's better if we can understand in first hand what are the processes in other countries, on their own language as well, so that it's very important. And even though I am from the same neighborhood, I do it very humbly and respectfully for the work that the people in Ecuador has been doing for the last years, as you saw. So this is an analysis of this law that I prepared for this occasion in particular. Fortunately, as I was translating for a couple of years the book of Raphael and Sean, these topics, even though are not my focus of research, are kind of fresh in my mind, so I can reflect a little bit on that, and mostly I will want to share some ideas that I have about this process in particular, and mostly about the idea of animals, or let's say animal rights stemming from the rights of nature, which is probably what I think it's, at least for me, it's the most concerning part of all this issue and all this problem that has been developed in the last years in Ecuador. So let's start with the plan. So first of all, I will give you some background and context that also Tatiana shared in the previous presentation. Then a little bit of the object of the analysis, which is the LOA, the organic law of animals. I won't analyze the LODA, if you understood perhaps. The LODA is the one that was presented by the Assembly after this was redacted and drafted and worked by the Ombudsman and the rest of the organizations. And I won't take a look into the LODA because, as Tatiana explained, it's just a cutting up of the other one, cutting out of the other one, and it's not. It's going to be archived. It's like withdrawn. Yeah, that's it. So I don't think it really worth the time. And then a little analysis of the law, and then a couple of conclusions. And I think the law is more important to be analyzed on the LODA, because the law is what's probably most of you that work in NGOs or in lobby or in animal rights law, and in possible drafting of laws, is what you probably will do. It's the first draft presented to the Assembly, and then the Assembly is the one that is going to cut it out. So let's address the one that was cut it out. I think that's more interesting for you. So first of all, the background. Since I have been living some years in Europe, I realized that most of the northern hemisphere of the world doesn't really know how this looks. So I think it's very enlightful to show you that this is South America. This is in the South Pole. Oh, no, South Pole is only here. Okay. This is not called Falklands for us. It has another name, but it's something that we shouldn't discuss in this university in particular. So as you can see, Ecuador is one of the smallest, probably, countries of Latin America. Evidently, Brazil is huge. And these themes, or all this discussion about this law comes from a very, very groundbreaking, let's say, case ruled by the Constitution of Ecuador in 2008 the ruling is in 2022, but it started before. The Constitution of Ecuador is from 2008, and the Constitution of Ecuador is the one that recognizes rights of nature. But I think that there are some interesting things to to consider about the Ecuadorian recognition of rights of nature. First of all, it has a very strong connection with the native population. That is why they use this term Pachamama, for instance, that it's not used in the rest of the countries in Latin America, by the way. When I meet someone from Europe and they say, oh, Pachamama, yeah, but I'm Chilean. We don't have that language, actually. It's very local, let's say. And the other term that they use is and it's contained in the Constitution, is Tumac Causai. I think it's the right way to say it, and it's about good living and the good living of humans in harmony with nature and with the rest of non-human animals. And there are some articles, in particular, like Article 71, 72, 73, and 74, that contains rights of nature. And I would like to very briefly read a couple of those so you can understand how is the drafting and how is the let's say the understanding that this country has about rights of nature, that it is perhaps very different than the one that it's about rights of nature in other countries or in other cultures. So Article 71 states that nature, or Pachamama, which is a synonym, where life reproduces and flourishes, has the right to have its existence fully respected, as well as the maintenance and regeneration of its vital cycles, structure, functions, and evolutionary processes. Any person, community, people, or nationality may demand that public authorities comply with the rights of nature. In order to apply and interpret these rights, the principles established in the Constitution shall be observed as appropriate. As you saw before, there are many, many principles, particularly two that Tatiana already touched, that are contained in this regulation of the rights of nature. Then we have Article 73 that sustains that the state shall apply precautionary and restrictive measures to activities that may lead to the extinction of species, the destruction of ecosystems, and the permanent alteration of natural cycles. The introduction of organisms and organic and inorganic material that may permanently alter the national generic heritage is forbidden. So, if you see, it's very, very ecosystem focused and very species in broad term focus. Okay, so it's not animal centered, it's not individual animal centered. And then we have the Estrellita ruling. Say this is the basis of the law that we are going to explore afterwards. Then we have the ruling of the Estrellita case from 2022, as I said, and this ruling, what sustains is because the Constitution of Ecuador recognizes rights of nature, and Estrellita was a monkey, that it's an animal, and animals are part of nature, therefore animals can be considered as well right holders. But, in my opinion, it's not that simple. Well, just to show you that there is one thing that is very interesting or very important as a background, that it's that in the Estrellita ruling, let's say that the recognition of animals as subjects of right constitutes the most recent phase in the development of their legal protection, which is based on the recognition of them as living beings with an intrinsic value and makes them holders of right, but because they are parts of nature. And it instructs, as we saw in the previous presentation, the National Assembly and the Ombudsman Office to work, the Ombudsman Office, with the citizens and NGOs, etc., 6 months to work in a draft, and then 2 years for the Assembly to approve it. As we saw, the Assembly didn't approve it, changed it a lot, cutting it up mostly, and now is withdrawn. But this is something that I think we need to reflect on, about rights of nature versus animal rights. Rights of nature this is very general ideas, of course, but it derives from a biocentric perspective. This is a holistic approach of ecosystems, to ecosystems, and the elements of nature and the diversity, considering that, for instance, diversity has an intrinsic value. This is more a field of environmental law, not of animal law, let alone animal rights law. Most of the cases, it seeks for environmental protection, which is related to, of course, climate change and environmental crisis. And it's a strategy of protection, granting right to nature, as Christopher Stone sustained in the 70s. And in the case of Ecuador and Bolivia, for instance, the understanding of rights of animals rights of nature, besides the fact of all these other facts about climate change and environmental protection, also derives from an understanding of the relationship of humans with nature, and that comes from the native cultures living there before the arrival of the Spanish. And then we have rights of animals, which is what most of us try to study and to push forward, that are based in a different logics, which is most of the case sentience. Of course, there are other findings and other explorations in research about other possible capacities, or inherent value, or dignity, or other properties, autonomy, agency, etc. But what we have today, mostly in what we have as enacted laws, as we saw in the case of Spanish law and in other countries, is based on sentience. And if we can speak, and this is my humble opinion, I think that I know that some of us share that opinion, if we understand that rights, like subjective rights, as interests protected by law, legal protected interests, if animals are sentient and if an animal is sentient, therefore is an interest holder, and if it's an interest holder, this interest can be legally protected and therefore can become legal rights. So the logics behind both are very different. And the thing is that, what I think is that this stemming of animal rights, stemming from the rights of nature, can be considered perhaps a paradox because of some issues that I think that we can find within this alleged alliance. First is a theoretical, which, as I said already, I am a quirky follower in this regard. So I do think that subjective rights needs to be attached to a subject that it's an interest holder, and that which interest is legally protected. So it's theoretically, let's say, from this perspective, it's very odd to say that a plant or a river or a tree, etc., or even an ecosystem can be interest holder, therefore rights holder. There is another practical that, as you can see in this, again in Spanish, but it says the polemic sacrifice of goats and rabbits in 2 islands in Ibiza permits recover local flora. So we find all the time this clash between animal rights and rights of nature, and they are clashing. It's not a clear-cut thing that we say that because those goats and those rabbits were put in those islands by people who went to those places. They brought the goats because the goats are lighter and they give a lot of milk and they produce cheese, etc. They grow faster than a cow. So those islands were populated by humans bringing those animals. And those animals are reproducing by themselves, sometimes a little bit out of control. So now the problem is, they are attacking the flora and the fauna of the island, and we have these animals. So the decision of the clash of those kind of rights, it's complicated, and probably, and in the most of the cases, especially with the climate crisis and the massive extinctions that we are facing, probably the rights of animals are going to be less considered than the rights of nature. Same case in almost every island. In Chile we have islands as well, and we have the same problem: rabbits, goats, etc. And There is another problem that I think that it's clear in the way that the very Constitution of Ecuador understands the possibility of rights of animals, and which is something that it's considered for some that have made some analysis of this law like a kind of contradictory way of understanding these rights, and perhaps it is, but at the same time, we know that we are living in societies where everything cannot change from one day to the other, so this law and this constitution admits some important degrees of contradiction. So here you see the Constitution say that individuals, communities, peoples, and nationalities shall have the right to benefit from the environment and natural resources that enable them to live well. And animals are considered, of course, resources. Then we have the duties and responsibilities of the Ecuadorians without detriment to other provided for in the Constitution and the law are to respect the rights of nature, preserve a healthy environment, and use natural resources in a rational, sustainable manner. Well, as you can see, the rights of animals really are starting to see themselves like becoming nothing at the end. And then we have food security in the same constitution saying that it shall be the responsibility of the state to ensure that animals intended for human consumption are healthy and raised in a healthy environment. So it becomes quite clear that it's not that clear that we can extract animal rights from the rights of nature, at least in this kind of let's say, design. And the same we can see in the Estrellita ruling. And this is something that Tatiana also touched on her presentation, but it's something that it's difficult to manage if we are speaking about animal rights, animal thick rights, as Rafael proposed this morning, that it's the way we want to understand rights, to really speak about rights. And the ruling states in paragraph 102 that consequently the rights to life, physical integrity, this is speaking about Estrellita and animals individually considered, right? And others must be interpreted based on the principles, since biological interactions are the foundations of the interdependence, interrelation, and balance of ecosystems. Therefore, when a predator kills its prey in accordance with the food chain, it does not illegitimately violate the right to life of an animal. And then it states that the latter is of utmost importance, particularly with regard to the relationship between humans and other animals, insofar as humans are predators and, being omnivorous by nature, cannot be denied the right to feed on other animals. So I am showing this not to say, oh, this is a disaster, it's a total contradiction, because I don't think any of us are entitled to say that about another country or another ways of understanding their communities and organizing themselves. However, just what I'm trying to suggest is that it's not that clear-cut, considering that rights of nature is the basis for rights of animals. That's the point. And of course, in my opinion, this could be very, 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 very true in the, 4,000 before Christ or something like that, but we are not living in that predator chain anymore. And most of animals that are vulnerable nowadays doesn't live in nature. So this chain food and predator idea of humans over animals, it's kind of perhaps it's, what's the word? It's outdated. Yes, I was thinking about overrated, but no. Oh, as well. And this is a logical thing that I was thinking that it's a logical problem here, because I don't think it's a logical conclusion. The premise is, and this is what the ruling says, and the ruling states, nature has rights, animals are part of nature, therefore animals have rights. I don't think that it's quite logic, because I don't think that follows from it. And there are two examples that came to my mind just yesterday. If humans have a right to vote, and newborns are humans, their newborns have a right to vote? No, because there are so many other things to be considered. Age, moment, legal system, voting for what, etc., etc. And similarly, if humans over 18 years old have a right to vote, and migrants, not residents, over 18 years old also are humans over 18 years old, therefore every human in a country has the right to vote? Not necessarily. So I think it has, logically, it has also flaws. And then this is something that I listened to when I was in Argentina some weeks ago. And some of the colleagues there said that, oh, I think personhood is, speaking about animal personhood, it's like speaking about titles of nobility. It's like you give them to someone, it sounds very, very fancy, but it doesn't really make any difference. So perhaps we can think the same about rights, and particularly rights like the ones of these kind of laws, or these kinds of rulings, or these kinds of constitutions. And this is a guide that I crossed, it just crossed my memory, my flashback memory to my high school times. And this is a very, very, very clear example of a title of nobility. Someone who went to Mexico when it was not called Mexico yet, in 1529. He made $1 million like he won a lot of money, let's say. He won a lot of money for the crown, for the Spanish crown. So he went back, he was a military, like not a noble, of course. He went back to Spain, super millionaire, with ships full of people, full of natives, full of gold, full of everything. And they say, and the crown said, oh, you did it so well. Now we are going to call you the Marquis of the Valley of Oaxaca or something, but it's a valley in Mexico, in that date. But the thing is that in Spain, he was no one. He was important probably while he was in Mexico, but the nobility in Spain said, he has never been one like us, and he will never be. He has the name, he has the title, he has the money, but he will never be one of us. So that is the tricky thing with words, finally. And I think that is something that needs to color our attention, and not give titles of nobility just to feel happy about it, and not consider that that really can make a difference if you don't make it like in a more comprehensive manner. So I don't know how I'm in time, Rafael. Just, okay. So this is the law. What I want to express is that the law is super long. It's super, super, super long. Like when I said, okay, I will do the presentation, and then I saw the size of the law, it was a real nightmare. So as you can see, it has like 100 pages. It's one animal rights law. It has 80 articles, a preamble, 3 titles, general provisions, obligations, prohibitions, infringement, national system of the promotion, which is nice, but it doesn't have teeth, as we can say. I don't know if that is something that it cannot do too much. General transitional, reformatory, and final articles, and it is an organic law. And that is also something that it can be considered tricky, because the quorums to enact it and then to modify it are super high. It's almost like the quorums that we have to reform a constitution. So it's super, super, it was very, very difficult that it will pass the political filter and the institutional filter. So as I was saying, this is me trying to walk away from the law. Article 4 contains 22 principles. Article 5 says that the law is constructed under the following approaches, which is a lot of things if we try to system. It's rights of nature, ecosystem, rights of non-human animals, one health, one welfare. It's like trying to put everything together, which is commendable, but sometimes perhaps it's not very pragmatic or strategically viable. And then Article 7 contains 60 definitions. It defines things that are useful for some terms that can be useful for law. Normally laws contain some definitions. We are going on to understand by this, blah, 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 blah. But this one has definitions, for instance, of anthropocentrism, vivisection, things that we don't need the law to say that to understand what we are talking about. And then Article 9 sustains that non-human animals are subjects of, I have it here, that are subjects of right, and these rights are universal, inherent, inalienable, non-transferable, and interdependent. Article 12 contains 17 rights, and the following articles are separated by not species, but let's say classification of animals according to what if they are put in labor or companionship or used in experimentation, etc. It gets to near 100 very detailed rights, and very, very detailed rights, and very long rights. It's not like right to something. It's right to blah, 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 blah. That's one right. Obligations 63. Prohibitions 150. Chapter 3 contains administrative infractions and sanctions, and this is something that also caught a lot my attention, because it is like every other animal welfare law that contains administrative sanctions for administrative infractions. So where is the law enacting really animal rights, and how those animal rights will be really represented? That doesn't exist in this law. So general characteristics. It's a very extended and often redundant law. It's full of administrative welfare norms and animal welfare legislation in general. It's extremely detailed and technical regulation. It's not clear, there is no clear legal standing for animals, neither objective rights. And there is a very ample spectrum of animals involved, including insects. If the cat normally in animal rights law is sentience, this goes far beyond that. It has a whole paragraph about bees, for example, that we know are super important and are in high danger nowadays with climate change and everything. But we need to decide where we are going to put the limit of consideration in one particular law. It's not that in the rest of the legal system, for instance. So this is the analysis, and I will do it through the Fasel and Butler lens. Especially because I translated the book, so it's easier for me. And they have a chapter in the book, which is chapter 7, which is devoted to animal rights in legislation, as Rafael advanced this morning. And in that chapter, what I think is very, very interesting is that it has like a kind of a manual about how to perhaps draft an animal rights law that can be as feasible, as pragmatical, and as possible and effective that we can do nowadays. So I will put this lens to see if this law meets those criteria. So what we have here is, first of all, mechanism of law reform. Statutory law or constitutional law. As I told you before, this is a kind of constitutional law because of the quorum that it needs. It's like organic law, it's very near the quorums of a constitution. And if you do that, you have to try to make it short and general. And this is super long, super extensive, and super impossible, finally and sadly. Status, on the other side, are lower legislative hurdles to be changed. It's usually more detailed, include enforcement mechanisms, and are easier to pass. Broad or detailed language. We can do it wider. The rights provisions can cover most situations, so it's perhaps more advisable, and it's less limited on their scope, but this is, as I told you, more than 150 very detailed rights. So it's clear that they choose the detailed wording, which is more suitable not for this kind of laws, but for other kind of regulations that are that need more detail, like animals in experimentation for medical research, like the one that was explored this morning. That can be and should be very detailed, but animal rights law for many species and in different situations, it's kind of complicated to do it that way. And then we have the scope. We need to think about whether all or some animals should be granted. We cut it in sentient animals. We decide to go for some species, as it could be the case of the Great Apes Project bill, or we stick to sentient. As we can see in this project, it goes even beyond sentience. So it's very, very difficult to accomplish, exactly. Then we have legal status. And of course, if you decide to go for the species approach, you can have a look in another book written by one of our directors in 2024 that it contains the species membership approach, which is very interesting if that is the way to go. And we have the legal status, whether to say something about it or not. In this case, this law doesn't change the legal status of animals, actually. So the civil code remains the same, for instance, and the law doesn't say anything. Animals are no longer things or no longer property. It doesn't touch that issue. Procedural rights should be ideally in a law like this, and in this case, neither are neither existent. And then legal standing, neither. So the law, what does is creates a lot of obligations, a lot of duties, a lot of infringements, and the result, let's say the legal outcome of that is only infractions, administrative infractions. Substantive rights, should they be detailed? Should they be wide? In this case, we see that they decided to go very, very into the detail. And the conclusions. I will say it's not that bad. Although a high commendable effort, as I said since the beginning, I think it suffers from considerable problems, which is the hierarchy of the law that they decided to go through, which is a constitutional rank almost. Of course, it will demand a huge quorum to be approved, and that majorities are very difficult to be met nowadays in every country. Then we have the extreme detail in rights and in other welfare prescriptions, which is not also an idea for an animal rights law. It's not clear and it's too ample in scope. As I was saying, it goes beyond sentience, so it is quite wide. It doesn't count with procedural rights, and there are, in my opinion, reasonable doubts about the idea of animal rights stemming from the rights of nature, because of what I said before. So this is, thank you so much for your attention.